As people enter the room, I'm going to just tell you a little bit about this webinar and about the Greater San Fernando Valley Chamber if you're not a member. So welcome to the first webinar of 2024, which is our labor law update. I'm Nancy Hoffman-Vaniak, and I'm CEO of the Greater San Fernando Valley Chamber of Commerce. And we're so happy to see so many people here. This is always our most popular webinar, but definitely this year, thanks to Kristina and the other partners at LANDEGGER, VERANO, and Davis, we have a lot more people joining us today. If you're not familiar with the Greater San Fernando Valley Chamber, we have been around since 1911, about to celebrate our 113th birthday, 114th birthday. I can't keep up. It's old. But coming up soon in February, that's going to be our anniversary. We started off as the Van Nuys Chamber in 1911, and we have merged with other chambers over the years, and now we're a regional chamber that covers every community in the San Fernando Valley. Coming up, just so you guys know, this is labor law, we're getting ready to have our employer poster sets go out. Some people on here, if you're a member of the chamber, you automatically get one free poster. If you need additional ones or ones in Spanish, you can order from us, and Fumi will drop the link in the chat for that. I know that many of you who aren't members have also already ordered those poster sets. We have not received them yet. I'm sure a lot of you are familiar with the governor, which Kristina is going to talk about, some new laws. He had to sign them first. We're going to give out, and by the way, if you're going to request to record locally, we're not allowing that. We will post this afterward and send it out. So no separate recording. So anyhow, we have labor law posters available, which are really important because Kristina's going to tell you there's a lot of new laws. And what is it, Kristina? Like, you could be fined like $25,000 for just not having the right posters up. So sure. If you're not a member of the chamber, the $26 fee or whatever it is, it's a lot better than a $25,000 fine. Also, just want to tell you a couple events coming up. If you're a bigger business, this is just exciting for us. We have our Women of Impact lunch on February 29th, and we're featuring female first. So we have Mayor Karen Bass, we have Treasurer Fiona Ma, Stephanie Wiggins, who runs Metropolitan Transportation Authority, which is the third largest transit authority in the nation. Rachel Michelin, who is the first female to run the California Retailers Association. You all know smash and grabs are a big thing right now. So she's a really real powerhouse in the state of California. And I'm missing someone. Oh, Dr. Eva Garcia from UCLA Health. Interesting story here. Healthcare in the nation, only 29% of women are in leadership, and UCLA Health is 54% women in leadership. So we're really excited. We couldn't get Jonice, their CEO, to join us because she has a board meeting. So she asked if Eva can, because Eva runs UCLA Health's Physicians Group, which is the largest physicians network in the nation. So we're very excited about that event, and hopefully Fumi will put that in the chat too. You could join us. And with that, I'm going to introduce Kristina, because now I think most people are here, and we'll get going. So I know a lot of you are already Kristina's clients or clients of LANDEGGER, VERANO, and Davis. And many of you know her from our chamber as one of our board members, and also who's done this labor law workshop for us for many years. So Kristina is a California employment lawyer, and they're based in Encino, which is here in the San Fernando Valley. And they serve employers all over greater Los Angeles and all over Southern California. I know people have called me, like I'm talking to Jeff Haas when he came on, when he needed someone, I referred him right away to Kristina. She received her JD from Southwestern Law School in 2001. She also received her BA with honors from the University of Southern California Political Science. Before joining LANDEGGER, VERANO, and Davis, she ran a solo practice devoted to advising employers in employment law matters and representing employees in a wide variety of employment disputes. In order to broaden her understanding of the employer-employee relationship, she subsequently specialized in complex business litigation, focusing her practice in areas of employment, employee benefits, and healthcare litigation. And when she came to LANDEGGER, VERANO, and Davis, she discovered her passion for educating, training, advising, and defending employers in all areas of labor and employment law. And we all know in California that is a very important job to have. So I'm going to turn it over to her, who's going to start this. We want to get up as much time as possible. We say this is an hour, but because we had so many people coming in, Kristina, we're probably going to have to go over a little bit over an hour, because we want to make sure you guys get enough time to ask questions. If you have questions, please pop them in the chat and we will moderate them. So Kristina, take it away.
Good morning. I'm really excited to see so many faces and screens. I can see your names anyway. So Happy New Year to everybody. Nancy, thank you so much for hosting this. annual event. I think that, you know, I gotta tell you guys, Nancy and the Greater San Fernando Valley Chamber of Commerce, where I am a board member, is honestly the best chamber of commerce that I know of, just because of how strongly it advocates for businesses, how much it has done for our business and for our clients. So Nancy, Fayumi, thank you so much for having us and for hosting this annual update. I think the labor posters is an essential thing, so make sure that you do reach out to Nancy about labor posters, because those are really important. As she mentioned, the penalties are pretty steep. So let's just begin. This is our Business in Focus webinar. It is a series, part of the San Fernando Valley Chamber of Commerce, and we are very happy that you guys joined us this morning. Great to see you, Jeff. We still have to do lunch, and so many of you here. Really glad to see you here. So let's dive right into it. Let's go over the key bills that you really want to be in the know about. So again, just like last year, same channel, right? Mr. Newsom was very busy this year, or last year, I should say, implementing very broad changes for us that directly affect you and so many of your employees. I would say most of your employees. So let's dive right into the key one, which is the minimum wage update for the state of California. We've got $16 per hour for all employers, and this is regardless of size. So make sure that you update your hourly rate if you haven't already. I think that most, if not all of you, are up to date, so I'm very happy to see that. And also make sure that if you have salaried employees, that you increase your annual salary for those employees to $66,560 annually. I know that some, if not most of you, have had conversations with us about, is this employee truly going to meet the salary test as well as the duties test? And if you have questions about that, we can talk about it afterwards. As I'm sure you know, local municipalities, counties set their own higher minimum wage. And so you want to make sure if you are, if your employees perform at least 2 hours per work week in the city of LA, that they're getting paid $16.78. And I have the rest of this. And by the way, this PowerPoint will be made available to each one of the attendees today. So you will walk away with a copy of this. Okay, so no need to take notes. And also just make sure we get this question almost every single year. The minimum salary for those exempt salaried employees is based on the state minimum wage only. Okay, so it's not based on the city of Los Angeles, so don't have a heart attack. So let's move on to the next one. There is going to be a very confusing and very significant bump in minimum wage for healthcare workers. If you are in that industry, I see some of you on here are, do reach out to me. I will talk to you about this. But at the end of the day, I just want you to know you're not alone. It is a very confusing statute. Even attorneys at our firm, we are reviewing this very carefully to see who fits into what category. Okay.
Okay.
If you can please mute yourself so that we can continue without interruptions, I appreciate it. So what this is it is going to be effective June 1st, 2024. And you want to understand which category you fit into, because there is somewhat of a sliding scale for what the minimum wage is going to be for your facility, depending on the size of the facility or employer, depending on the location, the source of funding, and the type of facility that you are. Okay, so let's move on. And if obviously I'll take questions later on if anybody has them. Let's go into one of the newer protected leave of absences. Okay, and I got so many questions on this so far, you have no idea. So it's called the reproductive loss leave. And this applies to you as an employer if you have at least 5 employees. And the employee that this will apply to, or who will be eligible for this, has been employed for you at least 30 days. suffers what's called a reproductive loss event, and this can be anything they try to adopt and that didn't work out, the surrogacy failed, or the employee had a miscarriage, stillbirth, any of those things, unsuccessful assisted reproduction. The key to this, I will tell you, although this seems to be very confusing and maybe even frustrating for some of us, but you cannot request any documentation from the employee to certify this leave. So in other words, this law protects the employee's privacy, protects what the employee is going through. You're not allowed to push them to provide documentation to prove it, okay? If an employee experiences this type of loss more than once, which some or most employees who are going through this do experience this, we need to practice compassion, number one. And number two, there are some restrictions. The employee is eligible for a maximum of 20 days within a year or 12-month period. So if they are experiencing more than one event, this is the cap. And again, I think that, look, we're all humans, so maintain composure, maintain full confidentiality, and if in doubt, reach out for any questions. Regarding paid sick leave, I'm sure I'm going to get most questions in this category. I don't want you to panic, okay? Because a lot of you are already within the city of LA. And so I know that you may already be providing more than the California minimum. But if you were providing just the California minimum, you were providing 24 hours or 3 days. It has now been bumped up to 40 hours or 5 days. And I want you to pay attention to that phrase that says, whichever is greater, okay? What that really means is that if you have an employee who is working 10-hour days, okay, and that employee, instead of 8-hour days, that employee will be entitled to the greater of, which is going to be 5 days. It's going to translate for them into 50 hours of paid sick leave because they're working 10-hour days, okay? Whereas if you have an employee who's working 6 hours a day and takes 5 days of paid sick leave, then they get a total of 30 hours, then the employee will still have 10 hours remaining. So it is tricky. We do have to read the language, unfortunately, and be aware of it. And I know there will be tons of questions, so feel free to reach out. And the eligibility doesn't change, okay? So for an employee to qualify for this, they have to work for you at least 30 days within the year and satisfy your 90-day employment period before taking any sick leave. If you are subject to the local ordinance, City of LA or something else, then we are going to be continuing to pay at least 48 hours, which is 8 hours more than the California minimum. And I will go over a few other things under the California statute are more generous than under the City of LA. So we'll go into that in just a minute. In terms of everything else, remains almost the same. So if you have employees, you are providing paid sick leave on an accrual basis, continue to do so. The standard accrual method is 1 hour for every 30 hours of work that they perform. I suggest that you keep that method because it is the easiest method to calculate. It is also the easiest method for employees to digest. So let's keep up with that. And if you're front loading, then continue to do so. And we'll address any questions in terms of that. Keep in mind, the benefit of front loading is that under the California statute, you are not required to carry over any hours. Okay, so if none of your employees are performing any work within the City of LA, then, and you are using the front load method, then you don't need to carry over anything. if you're using the accrual method for any or all your employees, then you do have an accrual cap, which is now increased to a maximum of 80 hours or 10 days. Okay, this is a California increase from 48 hours or 6 days. So be aware of that, and we'll talk about it, I'm sure. Again, as before, you cannot force employees to use their paid sick leave. It belongs to them. And finally, some great news, the DIR decided to finally update their FAQs about PSL. So I posted a link on here that you can use to read more information about paid sick leave, okay? Moving on to the next update, which is relating to a potential claim for retaliation in California. Okay, under the current law, as some of you know, unfortunately, an employee can make a claim for retaliation under California law, and typically they're faced with a few elements that they have to overcome because the burden of proof is on the employee to essentially allege that the employer engaged in pretextual retaliation. So in other words, an employee faces some adverse employment action. So they're demoted, they are terminated, denied a position, and then in turn they have to allege that this resulted because they are engaged in what's called a protected activity. And it can be anything beginning with a complaint. It can be a complaint about unequal pay, a complaint about, I believe something unlawful is going on. So under the current law, they have to essentially meet this much higher burden. Under the new law, there is a presumption that the employer engaged in retaliation when the employee is facing this type of adverse employment action, discipline, or termination within 90 days of this protected activity. So whereas before we had to look to case law and say, oh, look, the complaint was so close in time to this discipline or discharge, therefore we can potentially infer that they're related. Now there is an automatic presumption that because it is so close in time that it is presumed that the employer retaliated. So obviously you can still overcome that presumption, and the way that you would do it is you rebut it with evidence that shows that you engaged in this adverse employment action due to legitimate reasons. But again, work with someone to make sure that you're protected. And as I always tell you guys, make sure that you document every single communication, document every single employment decision. Make sure that you are collecting witness interviews and that kind of stuff. And this is a very expensive mistake. The civil penalty for this is up to $10,000 per employee per violation. Okay.
Kristina, hold on, because
Yes.
my power went out, and so I wasn't able to give you questions that were coming in earlier.
Okay. I was wondering.
I thought my computer died, and then I realized because my room's so sunny, my whole power was out.
Oh,
Okay.
no.
Backing up really quick to the previous slides. $16.78, that's minimum wage now, $16.78.
Correct. Yes, that is for the city of LA. Yes.
Okay. Does the health, I don't even know what slide this was from because I probably wasn't on. Does the health workers include drug and alcohol treatment facilities when you were talking about?
Yes, it does, regardless of the number of employees.
Okay. And then not sure if it's just, okay. I don't know what's getting disconnected, but yes, we are recording this and it will be on our YouTube channel next week. Let's see, does this get offset from FMLA 12-week job protected leave, or is it completely separate? So you must have been talking.
Completely separate. Are you talking about the reproductive loss leave? Yes, it is completely separate. It's not offset.
Romina, does that answer your question? You can unmute and let me know.
Hi, Romina.
Okay, we're assume that it answers her question.
Okay.
Hi, yes, it does. Thank you.
Okay.
You're welcome.
do healthcare workers also include early intervention clinicians and therapists?
Yes, they do.
Can negative sick time balance carry over?
That's a very confusing question. Why don't we take it in greater detail at the end? Because I think we'll have some more time.
Okay.
We'll come back to it.
Okay, if we use the accrual method, 1 hour of sick leave, 30 hours worked for part-time employees is a requirement of 24 hours by the 120 day. Oh my God, this is like a word problem from high school. By 120 day, 40 hour by 200 days still required. You know, the old conditions.
Yes, it is.
Okay, if it is, that means we will have to increase the accrual rate to about 1 hour for every 17 hours to meet that requirement.
You can use an alternative method, but regardless of what it is, if it's something other than 1 hour per 30 hours, then it still has to meet that that requirement. So yes, whatever you have to do to meet that requirement, then you can do it.
Okay, if the or you can front load and then you don't have to worry about it,
Or
right?
you can front load and not worry about it. Exactly.
If the employee reports a situation to an employer and it gets corrected, then the employee violates the policy of which he made a claim of. Can we still discipline the employee? That's from the slide you were doing about retaliation.
Mm-hmm.
Want me to read it again?
Why don't we get to it? Because I do want to talk about this a little more specifically. So
Okay.
hold that and then raise your hand when we're in Q&A.
Okay, I have 3 employees with generous PTO scheduled, not vacation and paid sick leave. How can I confirm this meets the new PSL law?
Send me an email with your accrual on the PTO. We'll do the math, make sure that you're fulfilling it.
Okay, that's Janice, or you know Janice, our co-chair
Yes.
for Women in Business. If
Yes.
employees are paid an hourly rate plus commission, do they still need to be paid $16 an hour? The commission brings their rate to more than $16 per hour.
It's a very good question. And what you need to be aware of is if it doesn't, then you're in violation of minimum wage and minimum wage law. So what I suggest is that you have a guaranteed base because your commission's going to fluctuate. So we can talk about it offline because this is not as simple as anyone might think.
Okay, and then the paid sick leave, we require salary employees to take sick leave when they don't work. Is that what you're asking, Melissa? Are you requiring, Melissa Jacobson? It says the paid sick leave, you require salary employees to take sick leave when they don't work. Are you asking if you need to?
Yes, I'm sorry. Yes. Are we allowed to require salary employees to take sick leave when they don't work?
You're not allowed to require any employee to take sick leave. The paid sick leave belongs to the employee, so they have to choose to take paid sick leave. They can only take paid sick leave under the qualifying reasons, which is, in a nutshell, them being sick or a family member being sick, and them caring for the family member. So depending on the circumstances, they may or may not be eligible to use paid sick leave hours, but you as the employer are not required to do so. What you can control, though, under California law is vacation. Okay, so if they do have PTO or vacation, then you can require that they take vacation leave when they're out. Okay, we can talk more about this offline so we can keep going with the presentation. Any others, Nancy?
Oh, yeah, I froze. Am I frozen? I'm here.
No,
Can you
I
hear me?
can hear you.
Because I keep
Yes.
freezing. Hold on a second. Okay. Okay, the next, because and by the way, I know this is going to go over. I'm just going to say in the future, we need to schedule these for 90 minutes because there's a lot of question when it comes to this. What about healthcare workers in a subacute facility?
There is going to be 10 million variations of the type of facility. I won't be able to answer those questions right now. We'll need to take those offline because there's
Okay.
so many considerations, okay?
Okay.
But
Okay.
yes,
Okay.
that is one of the facilities that is probably defined under the statute. We'll have to go look to see the details, and then we'll have to look to go see which deadline applies to you. Okay, so please
Okay.
contact me offline.
Okay, does healthcare workers also include case managers, admin staff, and all the other staff located at the behavioral health facility?
The answer is likely yes. It's anybody who would be supporting patient care. And there is a very specific list that I believe we are still going to go into. So some of these questions may be
Okay, let me try to power through the rest of these questions. How does labor law apply to internship employees?
it's a very, very ambiguous question. It depends on which law and which sector and all that stuff. Again, I think this question is
Okay, that's
best
fine. We'll move
addressed
that to the
offline.
end. If
Okay.
a third party works for a hospital, do those third party employees fall under the healthcare worker minimum wage? Which, by the way, isn't that healthcare minimum wage is being postponed?
They may. The answer is they may. It is, and there's a lot of variations here. I won't be able to answer specific
Okay.
questions because it requires a lot of analysis.
Going back and forth. Okay. We
Yeah.
perform pre-employment and by cause drug testing, including marijuana use. So we're about to get into the marijuana stuff.
Yes,
So
let's
we'll hold that one.
questions.
Okay, hold on. Healthcare workers minimum wage is $25 an hour across California and municipal or counties. It is across it's California. The
It is
25.
California, yes.
It's SB 925. Okay, that's it. You can go on.
Okay, awesome. All right, so we were just about to go into the cannabis use, and I want to make sure you understand there are two updates, okay? They are Senate Bill 2188 and Senate Bill 700. Both become effective January 1st, 2024, and applicable to you if you have at least 5 employees, 5 or more. And the way that they work is that essentially there are more protections now for employees regarding cannabis use, particularly outside of work hours. And these two legislations impose additional restrictions on employers regarding what you can ask an employee about their past cannabis use and what you can do in terms of testing with the employee regarding their current use. And we need to really understand what the nuances are because there's going to be a lot of questions on this one. So number one, the critical aspect of 2188 is that it relates to drug testing. And essentially there's a distinction, or rather the law emphasizes the distinction between impairment and the presence of simply cannabis metabolites in the body. So what does that mean? Because it sounds so loaded. Cannabis metabolites don't necessarily mean that you are impaired. Okay, so if you have used and you have these cannabis metabolites in your body, that simply indicates that you have used in the past. Okay, so they're not necessarily psychoactive and they don't necessarily impair your functions. So the law is very, very technical in that it says, look, if the employee has these types of indicators in their body, that cannot be used against them because those indicators are not necessarily indicators that they're going to be impaired. Okay, so that's kind of a loaded thing that we need to work with a trusted laboratory, but essentially you want to make sure that you're not violating the employee's rights. In other words, if there is a psychoactive component to the cannabis that's responsible for impairment, we want to make sure that, yes, you are taking care of that and making sure they're not doing that. But if there isn't, then we also want to make sure that we're not punishing an employee who has these indicators in their body that show that, yeah, in the past they've used, or maybe over the weekend they've used, but that doesn't mean that they're impaired. Okay. Now, so the shifting, there's a shift in the testing focus now. The new legislation requires that the employers adopt testing procedures that identify this active impairment component, which is the TCH component, rather than relying on tests for non-psychoactive metabolites. So again, kind of like what I said, these psychoactive metabolites don't necessarily correlate that to impairment. So you want to make sure to talk to your laboratory, talk to whoever you're using for testing, that they are up to speed on their testing. Okay. That's essentially it. Under SB 700, it's also unlawful for you to request information about a job applicant's prior use. So you want to make sure that if if you are speaking to a job applicant, that you're not using it against them, that in their criminal history, it has information about prior cannabis use. You cannot, under this statute, use that against them in a hiring decision. Okay, we'll take questions about this later on. Were there any questions,
Yeah,
Nancy?
yeah.
Okay.
How do they indicate the cannabis metabolites at labs?
Well, that is something that the lab would have to screen for.
If
it's an applicant that's being tested, the lab would have to isolate those metabolites. And whereas before they might not have, they might have flagged it and said, ooh, they have them, like red alert. Now they can no longer use that against an applicant.
Okay. And then if a company performs pre-employment or by cause drug testing, including marijuana use, if the person comes back positive and they terminate them, are they in violation of this law?
Well, again, that's kind of a very loaded question. Again, it depends, right? It depends. Is the indicator an indication that they have these psychoactive cannabis metabolites in their body? And if so, then that may be an indication of impairment. However, if they are non-psychoactive, then that's past usage, which you cannot use against them. So yes, if you use that against them in a hiring decision, then you may be in trouble.
And then one of our members who provides like industrial health, they've switched to saliva testing for people who still want to test for marijuana. Any comments?
That's fine.
Okay.
Yeah.
Okay, that's it.
All right. Okay, so let's move on to this next law, and it's the Workplace Violence Prevention, and it requires most California employers to develop and implement a workplace violence prevention plan, kind of like we had.
Hold on. One more question just came in. Are drivers exempt from the law due to DOT regulation that is random testing? Back to marijuana.
No. Nobody, no, they're not exempt from it. No, not at all. In fact, I want to speak to something, which is that this California legislation has a provision that basically says that certain state and federal laws preempt this law. And so if there is something in the federal regulation, or if there is something in the state law that essentially requires that type of position, that type of facility to test, then that state federal law is going to trump this new law. Okay, so in other words, it allows the employer to have the right to protect the workplace and its clients against someone who is using and is impaired on the job. Okay, so again, if you have questions, let's talk offline. It is very complicated.
Okay, we're back to workplace violence.
Okay, so this next law requires almost all the employers to develop and implement a written workplace violence prevention plan, kind of like we had during the pandemic, where we had the COVID prevention plan. So think like a plan, multi-step, focuses on prevention, puts some people in charge of implementation, some 2-3 pager or maybe a 2-pager document that you need to have in writing. Okay. And you want to provide some training to your staff on implementation and the rules of the plan. And essentially it requires that you keep a log of incidents of any workplace violence. And it's kind of a broad topic, but anything that falls within the category would potentially apply. And if in doubt, ask. But the plan has to comply with the state's injury and illness prevention program. and the enforcer is going to be Cal OSHA. And there are some exemptions that apply to this, okay, including healthcare facilities and work sites that have less than 10 employees working at any given time when there's no public access, and the employer complies with the injury and illness prevention under the Cal OSHA regulation. Those are the exemptions to this requirement. Okay. The next one is non-compete agreements. And look, we kind of, almost all of us know now that non-compete agreements in California are generally void, unenforceable, and very limited, okay? And so previously there's been exceptions, very limited exceptions, to that law. And now we basically have a law that essentially prohibits an employer from entering into these types of agreements or attempting to enforce these types of non-compete agreements. And here's the kicker. Now it applies to any of these agreements that were entered into in another state, even if they were lawful in that state, okay? So again, California is really cracking down on this type of limitation. And so whereas before we were able to put into employment agreements some sort of thing, now you are required as an employer to notify your current and former employees. And it does give you a date, employees who were employed as of January 1st, 2022, and you have to provide this notice in writing if they had any unlawful non-compete covenants, provisions in their employment agreements, okay? And you have a deadline of February 14th to do it by of this year. So I know some of you, if not most of you, will be reaching out. So keep in mind that, you know, this is something that will be looked at, and there seems to be every year more and more enforcement of these laws. So you definitely want to keep in mind.
Kristina, if they have active shooter training, is this for violence with each employee against each other?
I'm not understanding the question.
Yeah, Ileana, what are you? I don't understand. Yeah, we don't understand the question. You want to mute yourself? It says we have active shooter training. Is this for violence with each employee against each other? Employees.
Well, look, I mean, it is a type of violence prevention program, but that isn't sufficient to fulfill your whole requirement. That's just one type of, you know, measure.
Sorry, I found the
That's
unmute
the question.
button. Can you hear me?
Yes,
Yeah.
I can hear you.
Sorry. So we are in the airport industry, and we are required by the city to train them yearly on the active shooter violence.
Mhm,
But when you said it's required by Cal OSHA,
mhm.
so now do we have to come up with a training with violence against employees among themselves? Because we do have a
Yes.
violence training.
Yes, you do.
But we don't have it
Yes.
among them. Like if an employee, you know, assaults another employee, I mean, that
Yes, that
we
is
have
a
it in our-
completely,
Okay.
Liana, that is a completely separate requirement.
Okay.
What you have is mandatory for you. This is in addition to that.
Okay, got it. Because we do have it in our policy, assault and battery among employees, but we don't have a training in place for that. So that's the difference for us.
Look, feel free to send me over what you have. It sounds like you have different parts that we can probably integrate into one. And
Got it.
that may be the way to do it, but it sounds like you've got different elements, but this needs to come together to form a specific policy.
Got it. Got it. Thank you.
You're welcome. Okay, so we were done with the non-compete agreements, and we were on to the NLRB update. Okay, so
Wait,
last.
wait, hold on. Because our employees hired before 1/11/2022 required to receive the non-compete notice as well.
Let's see, I think we're going back to 1/1/2020.
That's why I'm sorry, 1/1. I'm sorry, I read it wrong.
Yes, yes.
So if are
As
employees
of-
hired before then, are they required to receive the non-compete?
No, 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 no. It's specifically to employees employed as of 1/1.
Okay, do you have a sample policy for workplace violence people could use? Like a template?
I would have to put one together. So I would be happy to work with you on putting that together. I don't have a sample as of now.
Do we expect the state to develop the required training for workplace violence prevention, or should we develop our own? Okay,
We've
I'm just,
looked for that, and similar to how Cal OSHA developed like the COVID prevention plan. We've looked, we checked, we contacted Cal OSHA, but as of now, they have not. And because the requirement is now, we're gonna have to develop one. So, as of now, there's no guidance out there from the state.
okay,
Okay,
that's it.
good.
Yep.
All right. So we were on to the employee handbook. And as I was saying at the end of last year, we got this ruling and it was long anticipated ruling, to be quite honest. And the decision affects how employers draft and enforce employee handbook policies, any other standalone workplace policies, regardless of whether you have a labor union representing your employees or not. Okay, so that's key, because I want to make sure you understand how broad the applicability is of this. Even if you have employees who are not with the union, this may still apply to you. Okay, the board and the general counsel for the NLRB have taken an expansive view of who is covered by the NLRA, the National Labor Relations Act, and this includes almost all private sector, non-supervisory workers in the country. And like I said, regardless of whether they are with the labor union or not. Okay, this also will include misclassified contractors. Okay, so this is kind of like, again, like a very hot topic, but you may have, you may be a private sector employer who employs non-supervisory workers, and you may be classifying them as independent contractors, and they may be entitled to this type of protection. So let's just dive into what this is. I just want to make sure you understand who it applies to.
Hold on, do employers have to update handbooks annually?
I mean, no, not necessarily, but to be quite honest, you should have someone look at your employee handbook annually, because for the last, God knows how long I can recall since I've been an attorney, there's an annual update of some kind. Okay, so you do want to make sure that every single one of your policies that's in writing out there distributed to your employees is in compliance with the state law. So at least have somebody take a look and scan for compliance. Okay, so essentially under this new framework, when you have a policy in the employee handbook or a standalone policy, it doesn't matter, that has what's called a reasonable tendency to dissuade a worker from engaging in organizing activity, that policy from the NLRB's perspective is in violation of this new law. Okay, and so the NLRB General Counsel has the burden of establishing that this rule or policy has this unlawful effect. But once they establish that the employer's rule does have that tendency, then the employer has the duty to rebut the presumption. I mean, if they choose to, that its rule is unlawful. And what they have to do essentially is provide some evidence that it's legitimate and substantial business interest that can't be achieved in a more narrowly tailored rule. And look, if at the end of the day, you do have some egregious policy that, nobody reviewed for you, then at the end of the day, what you'll have to do is you will have to revise that policy to make it more narrowly tailored. And essentially nobody's telling you to, completely get rid of your rule that you need. You just have to narrowly tailor it to make sure no one's rights are being impinged on. Any questions on that? I do see some new question.
Sorry, I'm talking as one of your clients could not get in, so I'm trying to send her the link. All
right.
Hold on a minute. Do you have a sample template for employee handbook? That's the only new question.
No, there is no one size fits all type of employee handbook. But what we do here though is we could take a look at what you have. And if you don't have anything, then we can, put one together from scratch for you. But I will tell you that an employee handbook is a very personal type of thing, if you will. It needs to fit the employer's culture. It needs to work with your existing policies and practices. So at the end of the day, that is something that we will work with you on making sure that it fits like a glove for you. Okay, so feel free to reach out and get a quote from me. Okay, are we good to move on?
Yes, sorry.
All right, no worries. I think we're almost at the end here. So if people have more questions, please feel free to reach out. So one thing that I know some of you on here are in the hospitality industry. And this right to recall is just a total complete monster. So if you are in the hospitality industry, I know some of you are, hello, this thing has been updated and extended to expire December 31st, 2025. And so sadly, we battled for some of you last year to defend you against claims that were filed under this labor code section 2810.8. And sadly, we saw some employers get hit with really, really large fines for this. And again, this applies specifically to hospitality employees like in hotels, but essentially covers any employee who was laid off during the pandemic because of COVID-19. Okay, so there are these obligations to recall these employees, and there are very, very specific requirements that need to be abided by. And if you don't abide by them, the DIR has come down very hard on those employers. So, feel free to reach out if you have questions about that. And the last topic that I left on for us here is a loaded topic. I just want to go briefly into this topic. It's a very hot topic regarding arbitration and what's called Private Attorneys General Act. And these are the types of claims which are the single most expensive type of claims that can be filed against you. So you definitely want to know what these are and how to protect yourself against them. At this time, I'd like you to be aware, and I know most of you are, that this area of law has turned into a hot mess. And it's important for your company to review, number one, your wage and hour policies governing meal and rest breaks, overtime, expense reimbursement. Make sure that you're reimbursing employees for any necessary business expenses. Make sure you have solid timekeeping policies. No more of those employees who don't want to abide by policies. If they're not applying by, if they don't want to keep track of their meal break, if they don't want to record their overtime, if they don't want to abide by your policies, please make sure you come down hard on them and discipline them, and create a record of that. And then if you need help, please reach out to me. At a minimum, I'll add you to my email list so that you receive our free email blasts. But ideally, you work with someone to ensure that your wage and hour policies are compliant. And some of you may benefit from implementing or updating an arbitration agreement. Okay. I put up here some case law like Adolph v. UberTex that's significant in this arena. But in Adolph, for example, the court held that even after the employee's individual claim has been compelled to arbitration, an aggrieved employee can still pursue a PAGA action. What this means is that we can no longer use an arbitration agreement to completely shut down a PAGA claim, which we used to do last year in that short window of time. Nonetheless, an arbitration agreement can still be used to your advantage when strategically drafted. So again, feel free to reach out for a consultation of how this type of agreement can help you avoid these super expensive mistakes that we can all make. And that's it. If you have any questions, I'm here to answer them. Well, I think we might have a little bit of time here to go off on related tangents. So do we have any other questions, Nancy?
Hold on, let me see if anyone's put anything on the, nothing new. I know there was something new just came in. Super informative, thank you. Yes,
You're
Kristina,
welcome.
by the way, before, like, I know people might want to drop off, so thank you very much for this very informative,
pleasure.
wonderful webinar. And then someone asked about the gas mileage, 67 cents per mile.
Yes, it's new, it's being updated. If you have another arrangement that's in writing with employees, I'm fine with it, as long as you have a little thing in there that says, make sure to let us know if that doesn't adequately compensate you for the for your expense.
And I want to remind everyone that there are a lot of new laws that you will need new employer poster sets, and we do have them available. If you're not a member of the chamber, you could purchase them from us, and we have a very reduced price. And I know Fumi put it in the chat earlier, but we've got a lot of people drop on the, or come on the call, so we'll put it in there again, because they are coming out soon. And also, what else was I say? So look for that. I mean, look for that because you want to make sure you're updated. I know a lot of payroll companies provide them to you, but make sure you change them out. It's really important. And let me go back to some of the questions that are now coming in. If anyone needs to implement a software application to keep track of employee time, okay, you're selling. Well, okay, thank you. And also, Talene, we'd love you to join the chamber so that way you can continue to promote yourself to our members. Can we pay drivers time minimum wage if their regular rate is different?
That is a very loaded question. I do want to talk to you about that question in greater depth, because I have a lot of questions for that.
And we put your information in the chat.
Yes, you could potentially come to some understanding, but we really need to talk about what that means.
Okay, with regards to non-compete, you were saying that an employee can take my entire client list and phone numbers and emails and attempt to solicit them, and I am now powerless to do anything? Is that correct?
It's a very specifically defined thing, okay? So again, if it is something that you are restricting them from engaging in their business venture, that is, a sure thing. But you can no longer put something in your agreement that has a broad provision that prevents them from doing so. If they're going after your trademark information, we may have some additional protections for you. Okay, so it's a very fact-driven analysis.
Okay. If you have more questions, because that's obviously in depth, reach out to Kristina. Is there a limit in the time someone can claim business expenses with an employer?
I think it depends. I mean, the answer is it depends on what your policy is. And if you place the burden on an employee to say, look, you need to submit these monthly, there are going to be some exceptions to that. But look, the labor code section requiring you to indemnify your employee for necessary business expenses does not put a limitation. Okay, so if it's a business expense that you required to reimburse them for, which you typically are, then I would say no, it doesn't matter. But your policy can certainly have loopholes in it that basically state, if you didn't tell me, then I'm not responsible for not compensating. So there are ways to protect yourself. Okay.
And if an employee has negative sick time balance, can we deduct it from their lump sum awarded for this year? That was the one from before, I believe.
Yeah, I mean, I think that under certain circumstances, I would have to look at the pay stubs. I would have to look at the individual situation to make sure that that is something that you can do. But it really depends on what has been communicated and how it's been processed.
Okay, let's see, we
And,
do
and,
not,
and also, just before I let you go, please just don't allow negative balances. It's generally not a good practice.
we do not have paid sick leave for full-time employees, only paid time off. However, our accrual rate is 1 hour for every 19.5 hours. Are we still in compliance with the PSL?
You won't be, because the new rule basically states you need to have X number by 120th day, and at that rate, you won't get there. So you'll have to work with someone to make sure that you get there and have the proper accrual.
Okay, also, are we able to only provide front-loaded PSL to part-time employees while allowing our full-time employees to accrue PTO as previously mentioned?
Typically, it's the other way around. Typically, I have employers front load for the full times and do accrual for the part times.
Okay.
But you can do whatever you want as long as you're complying.
Okay, by the way, I'm taking off your share before, and I have a few more questions, but before everyone goes, we'd love everyone to come on camera and we'd love to take a quick screenshot because this is the biggest amount of people we've ever had for this webinar, and there's still, well, we have 111 people, we had 204 reservations. Okay, to clarify the drive time question, we pay the employee $20 an hour and their drive time at minimum wage is $16 an hour. Is that allowed?
Again, that is a loaded question because it sounds like there's additional potential compensation there that we need to account for. So that is something that we need to talk about and figure out, are they getting some additional commission? Is there some additional bonus that's included into that rate? And if it is, then we need to account for all of that so that you are factoring in the regular rate of pay.
Janice, Kristina's information was already in the chat for you. We'll put it in again if that's what you're asking. Okay, last question before we take a picture. Is it safe to say the best way to circumvent an unlawful non-compete provision is to use confidentially trade secret provisions to prevent the employee from using employer client list emails and work products?
I can't speak to that without researching it further. So I don't know if that's the best method, but I would say based on what I know from the prior research, that is one avenue that California employers may use to protect their trade secrets. I don't know how that has been modified with the new law, so that is something that I would have to research further. Okay, so feel free to reach out.